what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member. Before you enter, there's a thorough search of my body and my handbag in violation of protocols and courtesies extended to any Chief Justice, which protocols and courtesies are honored in the name of the nation, both in Ghana and outside of Ghana. And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the judicial service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samapa, a military officer who was killed with the 3 High Court justices, who was the Director of Human Resource of GIHO. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. As we all know, when a citizen is summoned before a court or any administrative or disciplinary committee, it is the duty of the committee or court to give the citizen a copy of the complaint that they are presiding over. You cannot be summoned without a writ, a petition, or a complaint. It is also the duty of that committee or court or tribunal to give copies of all documents that have been filed with them before the hearing is started. How does anyone defend themselves without a copy of the complaint that is they have to come and start? This Article 140 gives me copies of the questions that His Excellency the President gave to them. They refused to give me copies, a copy of the prima facie determination that His Excellency the President is supposed to have given to them. But they know that the President sent me copies on 27th March, of the petition on 27th March, 2025. And so they do not need to see what the President gave to them. They also claim to have copies of the responses that I gave to the President, but they will not provide the petitioners with copies of my responses. The difficulty with this is, because they are the independent body charged with the duty to conduct the hearing, what I have in my hand from the President could be different from what they have. And I cannot assume that the two copies are the same. Indeed, no tribunal does that. No tribunal will tell you, before you came here, We know that your landlord wrote to you, so we are looking into what your landlord wrote to you about, and so that is what we will be inquiring into. They will give you what the charges are that they are supposed to be inquiring into. Second, the petition itself has not been admitted into evidence and subjected to cross-examination by me or my lawyers. In this case, because they have permitted the petitioner who has so far given evidence of the petition we are supposed to be dealing with, Mr. Daniel Ofori, they have permitted him not to testify and confirm on oath what his petition is. There is no petition on the table. There is no evidence given by him on oath. He has not authorized anyone to testify on his behalf. So what are we inquiring into? Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote-unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that it will conduct the hearing not as an inquiry, but as litigation. So they rejected the use of CI 65, which was created for the regulation of inquiries, and said they will use the High Court Civil Procedure Rules, CI 47. Then they decided that each petitioner can conduct as his case, so they don't need to present the petition to them. Then they decided that the petitioners can call to confirm what they themselves have not testified to. So, ladies and gentlemen, because the proceedings are being conducted as if it is a normal litigation between the petitioners and myself, their lawyers now choose and pick which parts of the evidence that public officials present to put on the table. This is also in violation of known rules regarding proceedings of a committee of inquiry, because a committee of inquiry must have its own lawyer. And when it starts the proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. So the public officials who have been summoned supposedly on subpoenas, without the issue of subpoenas, just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition. And so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called. Like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies, that the witnesses have referred to. Anyone who has been to the Circuit Court or the High Court and made subject to the rules CI 47 will know that those rules never conceived that a hearing can be conducted without the claims, the defenses, and the issues being carefully laid out before the parties and accepted by all of them before a hearing starts. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the proceedings being held in camera behind the walls of a new lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee